This is an emergency federal alert for anyone with a pending immigration case or federal benefit in the United States. A new March 2026 directive under EM-26002 has quietly changed the order in which payments and immigration applications are processed. Some applicants will move forward immediately. Others could be pushed to the back of the line. The difference depends on your category, and most people will not realize they are affected until it's too late. If you have a pending immigration case, benefit payment, or adjustment application in 2026, stop everything. A new federal directive under EM-26002 has just changed the order in which payments and immigration cases are processed, and not everyone will be handled first. Green card applicants with pending I-485s, EAD holders waiting on I-765 renewals, family petitioners trapped in backlogs, and benefit recipients whose eligibility depends on verified status are all at risk right now. Pay very close attention to this part. March 2026 is the moment many queues begin to reshuffle in real time, and if you skip this update, your case could quietly move to the back of the line. Here's the hard reality. Processing order is not just about speed. It is about who gets looked at, who gets scheduled, who gets verified, and who gets parked. And here's what most applicants don't realize. Once a file is parked behind a higher priority workload, it can sit there without warning, without a public announcement, and without any single officer denying it, just waiting. That can trigger work authorization gaps, missed benefit reviews, and status problems that multiply fast. Most people will miss this deadline pressure because the system doesn't call it a deadline. It just changes the priority stack, and your file falls. Now let's break down what EM-26002 actually is, because the name itself is designed for internal use, not public clarity. EM-26002 is an SSA emergency message, operational guidance, that instructs field offices how to hit fiscal year 2026 redetermination goals and, critically, the order of priority for scheduling and processing those redeterminations and limited issue workloads. This next detail is where payments get delayed. The guidance emphasizes priority scheduling and verification steps, including scrutiny of citizenship and alien status proof, and directs technicians to verify immigration status through SAVE when needed, which can pause or slow outcomes that directly affect payment continuity. Source: at the same time, immigration processing order is being reshaped by DHS and USCIS internal policy holds and security-driven triage that can block final adjudication for certain categories, meaning cases may be processed but not decided. And here's the part most immigrants miss. USCIS has issued policy memoranda directing holds and re-reviews tied to national security and public safety priorities, including a hold on all pending asylum applications and holds on benefit requests for nationals connected to specified high-risk country lists, with interviews not waived for affected groups and a requirement for heightened screening. That isn't a rumor. It is written guidance to USCIS personnel, and it changes who gets cleared first and who gets held. Source: so what is the effective date pressure in March 2026? Pay very close attention to this part. EM-26002 states that a major release of FY 2026 redetermination workloads occurs in February 2026, and those scheduling and processing instructions become the operational reality as offices move into the March 2026 cycle, when appointments, evidence requests, and verification actions start hitting mailboxes and online accounts. On the immigration side, USCIS hold and review policies are already in force, effective immediately, under the memoranda, and they remain in effect until lifted by leadership through a subsequent memo, meaning March 2026 is not the start of the policy. It is the month when many applicants feel the queue impact at the exact moment they are depending on renewals, approvals, and uninterrupted payments. Source: before the scenarios, a retention warning you need to take seriously. Stay until the end, because scenario number 4 could impact thousands, including lawful immigrants and mixed status families who rely on federal payments, and whose eligibility can hinge on verification timing. And here's what most applicants don't realize. You can be fully eligible and still get disrupted if your category is scheduled later. Your proof is marked alleged or unverified in a prior record, or your file gets flagged for additional checks at the worst possible moment. Scenario 1. You are a green card applicant with a pending I-485, and your EAD or advance parole is your lifeline. This next detail is where cases get delayed. If USCIS routes your file into enhanced screening or hold workflows tied to national security priorities described in USCIS memoranda, your case can proceed through steps but not reach final adjudication until additional procedures are operationalized or the hold is lifted. If your category is not prioritized, you may not get scheduled for interview when expected, or you may get an RFE that stops the clock. Delays can extend from months into an indefinite hold period, and the legal risk is simple. Your work and travel plans collapse first, then your status stability gets tested next. Source. Scenario 2. You filed an I-765 renewal because your work permit is expiring and your employer is watching the calendar. Pay very close attention to this part. USCIS guidance for certain populations explicitly removes interview waivers and expands review. And for applicants tied to listed high-risk country criteria, even routine benefits can be pulled into slower lanes. If your category is not prioritized, you may be waiting while other security priority cases are processed first, and you are the one who takes the hit: job loss, unpaid leave, or termination. If your filing is time-sensitive and you miss the renewal window, you can lose lawful work authorization even though your underlying case is still pending. Source. Scenario 3. Your family-based petition is stuck in backlog, and you thought family cases were protected or would be treated as a humanitarian priority. And here's what most applicants don't realize. USCIS policy language makes clear that family-based immigrant visa cases are not automatically or broadly exempt from heightened restrictions and scrutiny in the specified frameworks, and final adjudication can be delayed while procedures are reviewed or applied. If your family case is not in a prioritized category, it can be accepted, moved, and then stalled before a decision. That means more months apart, more lost time, and higher legal exposure if dependents age out, work permits expire, or travel becomes impossible. Source. Scenario 4. You are an immigrant receiving a federal-related payment, most commonly SSI-related support, or a payment that depends on continued eligibility and verified status, and you receive a sudden review letter, a documentation request, or a scheduling notice. This next detail is where payments get interrupted. EM-26002 instructs field offices to follow an order of priority when scheduling redeterminations and limited issue actions, and it explicitly emphasizes verifying citizenship and alien status when prior proof is alleged, blank, or questionable, including verification through SAVE where required. If your record gets pulled into a high-priority review bucket and you cannot produce documents fast, the practical risk is payment disruption, while the system resolves status, identity, and eligibility factors, even when you have done nothing wrong. Source. Scenario 5. You are already in secondary review, background checks, or RFE status, meaning your case is not moving forward. It is waiting on proof or clearance. Pay very close attention to this part. When an agency prioritizes certain workloads, secondary review cases often do not move to the front. They get managed in batches, and your response deadline becomes the danger zone. If you miss an RFE deadline, the result can be a denial, not a delay. If you respond but your category is not prioritized, the response can be received and still sit. The delay increase can be severe because the file is now complete but not urgent under the new priority stack. Now, the financial and legal consequences become far more serious than most applicants expect. This is not about a short inconvenience or a few extra weeks of waiting. This is where people lose years of progress. And here's what most applicants don't realize. A simple processing delay can quickly turn into a full legal status crisis. If a delay creates a gap in work authorization, you may be forced to stop working immediately, even if your renewal is pending. Employers are required to comply with federal verification rules, and if your authorization expires, termination can happen fast. That job loss can then trigger a chain reaction: missed rent payments, loss of health insurance, interruption of medical treatment, car loan defaults, and mounting credit card debt. At the same time, delays in benefit processing can freeze critical support payments, leaving families financially exposed during already unstable periods. What looks like just a backlog on paper can become a direct threat to your livelihood within weeks. The legal risks are even more severe. When immigration cases slow down, applicants are often forced to refile forms, redo medical examinations, attend new biometrics appointments, and pay thousands of dollars in new government filing fees. Each additional filing increases scrutiny and the possibility of new requests for evidence. And here is the part that carries long-term consequences. If a processing disruption causes someone to fall out of lawful status, and they later leave the United States after accumulating unlawful presence, federal law can trigger re-entry bars. These are commonly known as the 3-year and 10-year bars, depending on how much unlawful presence was accrued before departure. That means a delay today can block lawful return for years. A single shift in processing priority or eligibility can disrupt employment, damage financial stability, and permanently alter an immigrant's legal future. Here's the step-by-step action plan, and I'm going to be direct because timing is critical and delays can permanently damage your case. Do this today, not next week. First, identify your exact case category and understand the specific priority class that applies to you under current federal processing guidelines. Do not assume you are in a standard queue. Confirm whether you fall under a redetermination review at SSA, a payment adjustment category, a background or security review tier at USCIS, or a workload priority group based on filing type, travel history, prior denials, or documentation gaps. Many applicants misclassify themselves and later discover their case was placed in a slower processing stream. Pull out your receipt notices, approval notices, and any recent correspondence. Verify the form type, classification code, and filing basis. If you do not know your category with certainty, that uncertainty itself is a risk. Second, confirm every critical date attached to your case. Review your receipt notice dates, biometrics notices, expiration dates on work authorization cards, advance parole documents, or benefit eligibility review windows. Even a small gap between expiration and renewal can create employment suspension, benefit interruption, or compliance issues with your employer. Third, monitor official USCIS and SSA updates weekly, not monthly, because priority queues and internal processing guidance can shift without broad public announcements. Case movement often happens quietly. Finally, consult a qualified immigration attorney immediately if your category drops in priority, if you receive a request for evidence, or if you face a potential work authorization gap. A rushed or incomplete response to an RFE is one of the most common causes of denial. Acting early preserves options, acting late limits them. Rapid-fire Q&A, because these are the 5 questions flooding inboxes right now. Does EM-26002 apply to everyone? No. It is SSA operational guidance focused on FY 2026 redeterminations and limited issue actions. But if you receive or depend on eligibility-based payments, you can feel its impact through scheduling priority, verification, and documentation demands. Are already approved cases affected? In most cases, approvals stand, but reviews and re-reviews can exist in other agency guidance frameworks, and benefits tied to ongoing eligibility can still be rechecked. Can the priority order change again? Yes. Both SSA emergency messages and USCIS policy memoranda can be updated or replaced, sometimes fast. Will premium processing override this? It can speed specific USCIS petition types that allow it, but it does not automatically override security holds, background checks, or mandatory review frameworks. Can delayed applicants sue or appeal? You can pursue administrative options and, in limited cases, litigation like mandamus may be considered, but success depends on facts, timing, and whether the agency is acting within a stated policy framework, so do not assume a lawsuit is a shortcut. This federal order is already impacting March 2026 processing queues. If your immigration case or payment is pending, you must verify your priority status immediately. Share this with anyone waiting on immigration approval or federal processing. This update could determine who moves forward and who gets left behind. This video is for informational and educational purposes only and does not constitute legal advice. Immigration laws, federal directives, SSA procedures, and USCIS policies change frequently and may be updated without prior public notice. The information discussed is based on publicly available guidance and general policy analysis as of the date of publication. Every immigration or benefit case is unique, and outcomes depend on individual facts, documentation, and eligibility requirements. Watching this video does not create an attorney-client relationship. For advice specific to your situation, you should consult a licensed immigration attorney or qualified legal professional.